May
Yes, it's
no, so I beg to mention item number 28, Lord.
28.
Yes, Lord. Maybe after 2 weeks, Lord.
Okay.
I'm on the I have blocked it. I'm for a petition. I've taken consent from the government. Like,
উঠাই দিয়ে না উঠাই দিয়ে আর অলপ তলত কিবা এটা দি দিব লাগে এইটো দি এইটো তাত ৰাবাৰ এইটো নহয় ৰাবাৰটো লাগি থাকে অলপ এনেকে দি দিয়া না এনেকে দি আছে অলপ এনেকে দি আছে না এনেকে দি সেইটো ক'তো ৰাবাৰটো ক'তো থিয় কৰাই দিয়ে সেইটো অলপ তলত কৰি দিয়া হৈ যাব অলপ তলত দিয়ে বাছ হৈ যাব হ'ব চব হ'ব দে থাক দে বঢ়ি হ'ব ঠিক আছে অ'কে আইটেম নম্বৰ
28, Lord.
28
Yes, Lord. After 2 weeks, Lord.
ঠিক আছে এটা ঠিক আছে You're for whom?
I'm for the petitioner also on behalf of S. Thakur, Lord.
Okay,
I've taken consent to inform the government.
okay. 2 weeks.
2 weeks, Lord.
21 matter.
28.
No, 21 matter.
Yes, Lord. Yes, sorry. Yes, Lord.
It cannot be a 28 matter. We do not know what will happen in
I'm
28.
thinking about that number, Lord. Sorry, Lord.
On a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks. Yes.
Obliged.
Otherwise, pleadings have been exchanged or not?
I think I was not told. Lord.
You should go by the pleadings. Song 28 to 28 to. Yes, who's for the government? Which department?
Government.
Which department?
Police department. Lord. Police department.
Okay. Government advocate, any government advocate here now? Huh? You have not filed your reply affidavit. Last occasion in August 2023, you were given 2 weeks to file reply. On the last occasion, that is 2/8/2023, 2 weeks time was granted to the petitioners to file rejoinder affidavit, full stop. Para. Further time is paid for today, full stop. Para. In the interest of justice, 2 weeks further time is granted for filing rejoinder affidavit.
May I please, Lord? Well, item 16, my Lord.
16.
Yes, sir. I want to withdraw, my Lord.
You got the relief?
My Lord, negotiation is going on.
Sri B. Rahman, learned counsel for the petitioner, submits that he has instructions to withdraw this writ petition.
With liberty.
What is it?
Regarding salary, my Lord.
What salary? What liberty? Withdraw this liberty with liberty. However, with liberty. Full stop. Who is government advocate? What is the duty? Who's there? Mr. Gogoi, no government advocate. What is this? What again? No, normally couldn't have. Chike sab Aru? D Bora. Okay, D Bora. Okay. Oh. Namata likhi diba. Sri so-and-so, Miss Learned Council, Learned State Council is present. Para. Writ petition is accordingly dismissed as not pressed with liberty.
Hello.
As prayed for. Yes.
Right, Lord. With the consent of the other side, my Lord, I beg to mention item number 35, my Lord. Here I need to file my activity in reply, my Lord. They have filed their opposition, my Lord. I have taken the consent. Item 35, my Lord.
Okay. Oil India.
Well, they have filed their opposition. I have taken the consent, my
Lord. On a prayer made on behalf of the petitioner, matter is adjourned by 2 weeks.
My Lord.
To enable filing of rejoinder affidavit. Is there any interim order? No.
No, my Lord. May I please? I
Yes.
beg to mention item number 23, miss.
23, yes.
The matter may be listed after 2 weeks
Why? What has happened?
because my senior is not clear.
Sri D. A. Kayum, learned counsel for the learned counsel submits that his senior Sri B. C. Das is unwell. PNRD informed
Yes, miss.
and unwell, and accordingly he prays for an adjournment. Full stop. Para list after 2 weeks.
Well.
Yes.
My lord, I have one more with regard to item 21, my lord.
Yes.
I have taken the consent of the other side, my lord.
Yes.
In the past of our day, my lord.
Health Department
My
consent taken.
consent taken, my lord.
On a prayer made on behalf of the petitioner, matter is adjourned. Adjourned by 2 weeks.
Right. Deeply obliged.
Sri B. Gogoi, learned standing council, health is present.
Deeply obliged.
Item 49, my lord.
Yes.
I appear for the respondents NHTCF,
Yes.
making a prayer on behalf of T.R. Gogoi, the affidavit in opposition to the additional affidavit filed by the petitioner. That is the vetting.
Additional affidavit.
Yes.
Affidavit in opposition to the additional affidavit. What
Yes,
is
my lord.
this?
My lord, it has been sent for vetting and we'll be filing it with.
No, where is the scope of filing rejoinder affidavit to an additional affidavit to a reply affidavit? Where is the scope? Where does it end? Where does- what is the stage where pleadings come to an end? There has to be a stage. It cannot be an indefinite process. It is submitted by Sri P. Bharadwaj, learned counsel, that further pleadings which are required to be filed is at the stage of vetting.
Fine.
Full stop. List after 2 weeks.
Fine.
If I may appear for the petitioner in this matter, your lordship, I may be allowed to take steps upon respondent number 11 to 24,
Not taken.
not taken.
The petitioner, the learned counsel for the petitioner, in the meantime, is directed to take steps upon respond numbers
11 to 20.
11 to 24. Private respondents,
Private-
steps 24 by registered post with AD, steps within 3 days.
May I please, your lord? So with the consent of the other side, I'd like to mention item number 29 of the daily list.
29 years.
In this matter, lordship, we have newly engaged lord, and we are going to file our Wakalatnama in this quick lord. Lordship,
29 for whom?
lordship for the petitioner lord,
Okay, 21 minute. What is your name?
N.K. Sharma lord.
Sri N.K. Sharma. Have you informed the agriculture department?
Lordship, already in.
Sri N.K. Sharma, learned counsel, submits that he and his colleagues have been instructed to appear on behalf of the petitioner, and the formal wakalatnama would be filed shortly. Full stop. He accordingly prays for and is granted 2 weeks time.
May I please, Lord?
Deeply obliged, lord.
Yes.
I beg, with the consent of other side, I beg to mention item number 19 of the daily list.
Yes.
Matter may be adjourned for the day as learned counsel Piridas is not well today, so any date may be given after 2 weeks.
It is submitted that Sri B.D. Das, learned senior counsel for the petitioner, is unwell. Have you informed the other side?
Yes,
My
Lord.
lord, it may be.
Unwell, and accordingly, a prayer for adjournment has been made. Full stop. Full stop. Para. List. Yes, tell us, Mr. Datta, date.
Any day, my lord,
After 2 weeks or so, any date by the end of
List.
May or starting of June.
Today is list on 3rd of June. Okay.
Much
I plead your lordship, my lord, in item number 22, I will be allowed 2 weeks time to file return type 22.
Okay.
I
CGC has filed
I-
affidavit.
Gogoi,
On the prayer of Miss S. Bora, learned counsel for the petitioner, matter is adjourned by 3 weeks to enable filing of rejoinder affidavit. Yes.
May I please, your lordship? I beg to mention item number 43 of today's list, lordship. I'm instructed to withdraw this application.
43.
Better become infructuous,
PP Borthakur.
lordship.
Sri PP Borthakur, learned counsel for the petitioner, has submitted that by flux of time, the matter has become infructuous. Full stop. Para. Government advocate, yes. In the earlier case also, your number later. Amitabh Chakraborty, A. Chakraborty. So is present. Writ petition is accordingly dismissed as infructuous.
Alright.
Was there any stay order?
No.
Yes, madam.
Please, your lordship. Your lordship, I beg to mention item number 31.
3-1.
Yes, your lordship. Your
Yes.
lordship, the engaged counsel is out of station due to some medical emergency. Therefore, she couldn't appear before this honorable court today.
Who's the English counsel?
Miss S. Das. She's appearing for respondent number 1, 2, and 4.
Okay. Earlier occasion also this matter was adjourned.
Yes, your lordship. Your lordship, we have also taken the consent of the petitioner.
Consent is okay, but it was adjourned on the earlier occasion. Why? She's on medical leave.
Yes, your lordship. Your lordship,
Okay,
yes,
inform the other side.
yes, your
Okay,
lordship.
2 weeks we are granting, but make alternative arrangements. It has been adjourned time to time. It is submitted that. What is your name?
Miss H. Das.
H. Das. Miss MS H. Das, learned counsel, appearing on instruction of MS S. Das, learned counsel for the respondent numbers 1, 2, and 4, submits that no, appearing instruction of not appearing instruction submits that Miss S. Das, learned counsel for respondent numbers 1, 2, and 4 is out of station on medical grounds. Full stop. Para. No, grounds and accordingly raised for an adjournment. Full stop. Para. In view of the above, list after 2 weeks.
Yes, your lordship. Highly obliged, your lordship.
Yes.
May I
Next.
please, your lordship, I beg to mention item number 40, your lordship.
40.
Yes, your lordship.
Yes.
The matter may kindly be adjourned for a week.
Here for whom?
D. Borua. I'm appearing on behalf of D. Borua. He's in this court.
Okay.
Only for a week.
18 matter, madam.
Yes, your lordship.
It is for orders. Why it is for orders? We'll have to look into the file, not now. We'll accommodate you, but it may be for steps or something else, not now.
Yes, your lordship. It was the law Lava Jivma, and we took the steps on 13th. Again.
Then we'll pass orders, appropriate orders where we are joining. That's all. Or you take your, it will come in its turn. Wait for your turn, not now.
Yes, sir. Mato.
Yes.
May I please? Item number 24
Hmm.
to become an infructuous matter.
AK Dutta, infructuous. Influx of time likhiba. D Chakraborty. A Chakraborty. G agonist. 24. Influx of time to likhiba. Yes.
May I please, your lordship? I beg to mention item number 42, lordship. Matter is-
42.
Yes, lordship.
Yes.
Matter is infructuous.
You are not in the file case. What is your name?
I'm S. Chetri, lordship.
You are on behalf of B Chetri.
B. Chetri.
Okay. S Chetri appearing on instruction of B Chetri. Who is for the respondents? A Chakraborty, government advocate. NRC, anybody NRC? Who is ECI? Election Commission of India. नाम भी लग लिख दी बा ए अली सगे ए अली इलेक्शन कमीशन एंड हेरी एनआरसी अधिकले নাই নেকি হোম ডিপার্টমেন্ট হয়েছে এই এনআরসি হেরি লিখে হ্যাঁ হু ইজ ফর এনআরসি নরমালি
Anita Parmal, like, supposed to see appeared.
এনআরসি ইজ মেইনটেইনিং স্ট্যান্ডিং কাউন্সিল nowadays home department is there. Please ascertain and okay, and the council has to be in the court, otherwise we cannot record the presence. Okay.
Certainly.
Okay. Infructuous, huh? 42, influx of time. Yes.
May I please, your lordship? I beg to mention item number 3.
3.
Lordship.
Yes.
The engaged council B takers were expired, lordship, and then another brief is not present in the other advocate. Lordship.
Who has passed away?
B taker.
B Deka.
Lordship.
There are other councils also.
The other council have no brief in hand, lordship. They have applicable certificate.
What is the full name, B Deka?
B taker.
What is the full name?
Binoy taker.
Okay. Exceptional case. Okay, you take the second brief, you make whatever arrangements, and we'll have it next
They
week.
have applied.
Yes. What is your name?
RL Sutia on behalf of Isodori.
Okay. R. L. Chutia,
Lordship,
Sri R. L. Chutia, Learned Counsel, appearing on behalf of the petitioners, has submitted that the concerned counsel for the petitioner, Sri B. Deka, has passed away, and the brief is not readily available. Full stop. Para. He accordingly prays for and is granted 2 weeks' time to reconstruct the file.
hold it.
Full stop. List on. It's a 17 matter. We'll give a date. List on. We'll have it on 4th of June. 4/6. Have you informed APDCL?
I will inform you.
Oh, don't make mention. What I will inform. Why do you make a mention? You know the practice of the court. Don't make mention without informing, taking consent. Not now. Don't never do this. Let it reach, or otherwise take the consent. APDCL. He has got some problem. Somebody has passed away. But don't make mention without informing. Okay. Sri B. Chaudhary. He is present for the APDCL. We are fixing on 4th of June.
Mal.
Mr. Been told that say B. Deka has passed away. So he needs to reconstruct the file. Okay.
Keep your.
Item 1, order Muslims.
May I please, your lordship? It's my humble prayer, your lordship, as far as respondent, performer respondent 3 and 4 are concerned, your lordship, their name may be struck off from this case, your lordship. This company belongs to the petitioners only, your lordship.
No, it's your choice.
Yes, your lordship. The name of the respondent number 3 and 4 may be struck off. That is my humble.
Your S. Chanchati,
Yes, your lordship.
this matter has been listed under the column within inverted comma order, no steps. Full stop. Para. Order dated 8/5/2024 of no, order dated 22/3/2024 of the Learned Loazima Court, read with office note dated 8/5/2024, reflect that steps for service of notice upon the respondent numbers 3 and 4 have not been taken. Full stop. Para. The Learned Counsel has, however, submitted that the said respondent numbers 3 and 4 being pro forma respondents, comma, their presence may not be necessary in the adjudication, and he accordingly prays for striking off the names of pro forma respondents 3 and 4. Full stop. Para. In view of the above, comma, the names of the pro forma respondents, respondent numbers 3 and 4 are struck off from the array of parties. Yeah, so what about the list after 2 weeks? No affidavit filed.
No affidavit filed.
Okay.
Highly obliged, your lordship.
Okay.
Wait, please. Basically, our claim is of regularization.
Yes.
Lordship should kindly come to page 29. page 29. Government of Assam.
Yes.
Government of Assam Social Welfare Department invites application from intending eligible candidates who are citizens of India as defined under Article 5 to 9 of the Constitution of India with required qualification for engagement to the post of Child Development Project Officer on contract basis. The engagement will be purely temporary or on contractual basis for a period of 1 year only on the following terms and conditions. Now, if the Lordship will kindly come to 3.
Yes.
After successful completion of the terms of their engagement,
Hmm.
the government in the Social Welfare Department may decide for future renewal of the terms of the contract. Else, she shall have to relinquish the job immediately after expiry of the contract. In due course, department shall take up the matter with the APSC for filling up this post on regular basis. And in that case, the candidates shall have to apply like other candidates appear before APSC for regular employment. Now, this was the condition in the my lord advertisement.
Hmm.
But there is no dispute that the advertisement was for contractual appointment.
Hmm.
And the petitioners were all selected and they were extended from time to time.
Hmm.
And till date, my lord, they are all working. Now,
SCDPO.
CD, Child Development Project Officer. I may give one information, my lord.
Yes.
In Assam, there are 230 ICDS projects.
Okay.
Out of this, only 22 CDPOs are appointed on contractual basis.
How many IC projects?
230. Only 22 were appointed on contractual basis. Now, out of these 24, my lord,
22, you said.
22, sorry, 4 left their services. And at present, the present 18 petitioners are in service on contractual basis. And I understand under the central government scheme, under which, my lord, the CDPOs are appointed, there is no provision for contractual appointment. Now, this is the position. If the Lordship will kindly come to page 39. Now, this is regarding deputation of the CDPO newly recruited.
39.
Page 39. Deputation of CDPO newly recruited for job training course. With reference to the subject cited above, I have the honor to inform you that NIPCCD Khanapara has arranged job training course of CDPOs with effect from April 20 to May 20 at their training institute at Khanapara, and are requested to depute 23 newly recruited CDPOs for the said course. Therefore, instructions and orders to the CDPOs enclosed list directing them to attend the training course. Basically, a document to show, my lord, along with others, the petitioners were also deputed for training. Now, various trainings were there up to page 49. They were all deputed and they completed their training. Up to page 49.
Yes.
Now, my lord, will kindly come to page number 50. This is a letter by the director.
Page 50.
50 to the government, where basically, my lord, the director said that we should be regularized. It was on 3rd of November 2015, 13th of November. With reference to the subject cited above, as directed by you, I am submitting herewith the proposal with justification for creation and regularization of contractual post of Child Development Project Officer under Social Welfare Department, that this that social welfare department is one of the most important departments implementing welfare schemes meant for women and child of the state under ICDS. Presently, the department has been implementing this scheme satisfactorily as per the guidelines issued by
Okay,
the
we have
Ministry.
read this. There is, he has recommended for.
Recommended,
Okay,
basically, yes.
okay.
Now, my lord will kindly see at page para 2, this is important.
Yes,
Total number of sanctioned posts or CTBO is 230. And out of
No,
230,
we have read this.
that I already pointed.
Yes, they are paid same salary, there is no discrimination.
yes.
And 18 are presently on contractual basis out of 230 total posts.
And my lord, para 4, he also says that we have been given all the required training to the full satisfaction of the authority. And all para 5, all contractual officers perform election duties in both so and so. And para 6, it says most of the above mentioned are postgraduates in various subjects. And 7 is very important, my lord.
Yes,
The regular employee with whom the contractual employees have to do equal duties, but regular employees get a great pay, house rent, allowances, medical allowances, daily allowances, and other allowances as admissible under the ROP at present, while those contractual employees are discriminatorily being deprived. So, Malad, this aspect was also, if not regularization, then equal pay for equal work. And I'll come to that. Then my lord will kindly come to page number 57.
five, 7,
Yes,
5th January.
yes. With reference to the letter on the subject cited above, I would like to inform you that for extension of service of contractual child labor project officer, government desires their performance report. Therefore, you are requested to constitute a 3-member committee to evaluate the performance of the in-service contractual CDPO officers under the district. The committee consists of 2 and 4. After considering the committee, we are also requested to evaluate the performance of the concerned officers and submit performance report for the last year, including the current year as per the format and form. Now, these are done, my lord. Eventually, we are all continuing. Now, the issue is, my lord, whether we can claim either equal pay for equal work, or, my lord, at least equal pay for equal work till we attain the age of superannuation, and secondly, or whether regularize. My lord, even if we follow the Uma Devi's dictate, mandate, para 53, there also, my lord, it says that we should continue without intervention of the court, and our initial entry into the service should not be illegal. Now, following that, my lord, so many judgments have come. Now, my lord, very recently there is a judgment of the Supreme Court, which I think is very important. My lord, should kindly have a look at.
Name?
My lord, this is Vinod Kumar versus Union of.
2021.
Oh, yes,
20.
2024 INSC 332. Now, what is most important is please come to para 4 of the judgment matter. In fact, here Uma Devi and all were taken note of. Now, this para 4, I think, my lord, it's a new dimension to the whole subject matter. The appellants has a lordship notice. Para 4.
This is
At page
reading,
4.
reading down Uma Devi
Yes.
by a bench of 2 judges.
My lord, I won't say it is reading down Uma Devi.
Yes, we had the occasion to deal with this judgment.
But Supreme Court has understood Uma Devi in this line. I would respectfully say,
This is reading.
para
down.
4.
We don't have anything, we are not competent to say anything, but
So, my lord, I think so far as precedents are concerned, I think there are few expressions with which we are familiar. For example, a judgment can be distinguished. A judgment can be explained also, my lord. Can't we say this is a judgment where Uma Devi has been explained? Of course, at the level, not at the level of High Court, at the level of Supreme Court. Now, what would be the, my lord, precedential value of the judge? If it is a judgment where earlier judgment of the Supreme Court has been explained, I think it does carry, my lord, precedential value. The appellants have approached this court.
You are reading which?
Para 4, my lord, at page 4.
Yes.
The appellants have approached this court, arguing that High Court erred in its judgment by failing to recognize the substantive nature of their duties, which align with regular employment rather than temporary or scheme-based role they were originally appointed for. Further, their promotion by regularly constituted departmental promotion committee, the selection process they underwent, and the continuous nature of their service for over a quarter of a century underscored their argument for regularization, and that High Court has incorrectly applied the principles from the case of Uma Devi to their situation. Well, here I would like to emphasize on one aspect, my lord. If the nature of duty which is performed by a contractual employee is of substantive nature, which is akin to the regular employee, then what would be the situation, my lord? I think this is an aspect which Uma Devi never considered. My lord, if I understood Uma Devi correctly, and in fact, my lord, that is how, my lord, the Honorable Supreme Court has understood Uma Devi, more than, my lord, better on the power of the executive, it was, in my humble understanding, my lord, rather a caution on the Honorable High Courts of the country that don't issue orders for regularization, I mean, in a routine manner. But as far as the executive's power is concerned, that cannot be taken away, my lord. For example, I'll just show the judgment, the Jammu and Kashmir case. If your lordship take on judgment,
Which one?
2017 3 SCC 410.
Name?
Jammu and Kashmir, my lord. Justice Chandrasud judgment, my lord.
Name case.
Yes.
Or bar, okay, yes.
Yes.
2017.
If your lordship will kindly come to para 11.
11.
The decision in Uma Devi dealt firstly with rights claimed by temporary employees to be regularized in service on the basis of long continuance, legitimate expectation, employment under the state, and directive principle. The second salient question which the Constitution bench was called upon to answer was whether courts should be justified in issuing direction for regularization based on such features as equality, long spell of service. On both counts, Constitution bench held against the temporary employees. Now, this is important. However, Uma Devi is not an authority for the proposition that executive or legislature cannot frame a scheme for regularization. Uma Devi does not denude the state or its instrumentalities from framing a scheme for regularization. I am on this matter. It was rather a fetter on the power of the constitutional court not to issue direction. It was never meant to be applied against the executive pilot because that power is inherent. Now, supposing in a given case, a case is made out for such a mandamus or a direction. Supposing, my lord, the executive does not act, then court can always issue a mandamus for consideration. Court will not direct regularization. Court can always ask the government, in these facts and circumstances, please consider framing a scheme for regularization, at least as a one-time measure. That was never stopped by Uma Devi.
No, will that be the correct meaning of the expression which you have just read?
Yes.
However, please read again.
Yes. However, Uma Devi is not an authority for the proposition that executive or legislature cannot frame a scheme for regularization.
Then
So
the
executive power is there.
Prerogative is of the executive.
Yes.
Uma Devi has not said is only restricting to the court's power.
Yeah.
Now, having said that, it will still lie upon you to urge
No, what I,
that we can issue a mandamus for consideration for
consideration
regulation.
is always there, my lord.
But will it again not come within the fetters by Uma Devi on a court
No, my lord.
for
Lordship is
regulation?
not direct regularization. That is what has been said. What has been frowned
No,
upon
but
is,
since 50,
no, in some judgments, lordships will find where court direct, regularized in this circumstance.
no 53 there is
Yes.
no doubt that no dispute that 53 lays
Yes,
down
let
the
us read
condition.
it once again, my lord.
53 lays down the three conditions.
Yes, yes,
10 years without any interim order of the court.
yes.
Initial entry was by a proper process. Proper process. These are mainly the parameters.
Yeah.
Now, if we can objectively assess or evaluate whether you have gone through this,
Yes.
then
Kindly see, my lord.
then it's a different matter. We can always do that. Follow 53. Consider
I can
regulation.
consider. That's all.
That we do.
That is,
But
that is
here,
only.
the
Yes.
one see you have
My lord, on the day when we approached, it was not 10 years, but today it is more than 10.
no. There is another issue.
Yes.
So you have structured your in your oral argument that you are on two broad basis. One is equal pay, equal work. That's another part which we are yet to apply our mind, and the other is regularization.
Yes.
Now we come back to the first advertisement of
Yes.
9/1/2010.
Yes, my lord. Yes.
The appointment was on contractual basis, but it doesn't end there.
Huh.
You have very fairly pointed out
Yes.
that the aspect of renewal has to be decided by the government.
Yes.
They have decided you are
From
kept
time to
on-
time work.
you are renewed, you are continuing.
Yes.
Then the third, there is another very important aspect.
That we have to undergo.
APSC.
Yes. No,
That
my lord, this is where, my lord, that is where I say that my nature of appointment will not determine my status. That is where para 4 of that, I mean, the recent judgment of the. And my lord,
No,
there are
that-
other judgments also.
no, that being the stipulation of your entry into the service, that
Yes.
in case of regular appointment by APSC, you
No,
might have been working, but you still need to go by the record.
my lord, my humble submission. Let department show that there is an enabling provision in the, my lord, central government scheme of making a contractual appointment. When there are 230
No, that-
ICDS projects,
No, Mr. Chaudhary, with all humility, that probably will not go into. You accepted that. Now you have entered into a contractual appointment. Now you're connected to question
now my
that you
lord,
could not have made contractual
this
appointment.
acceptance part has been dealt with by the Honorable Supreme Court. That is again in one judgment, my lord. Somesh Thapial versus Vice Chancellor of Vice Chancellor, my lord. 2021 10 SCC 116.
2021,
2021
NSCC
10 SCC 116.
116.
Yes.
Paragraph?
Judgment আছে নেকি?
Paragraph?
Okay. My lord, yes. Please from my lord. Now from 40 to from 42 to my lord 52. 2 pages, my lord. আছে নেকি? Oh, তাকে. Now I may read slowly, my lord.
Please.
The submission of the learned counsel for the respondent that the appellants have accepted the terms and conditions contained in the letter of appointment deserves rejection for the reason that it is not open for a person appointed in public appointment to ordinarily choose the terms and conditions on which he is required to serve. It goes without saying that employer is always in a dominating position, and it is not open to the employer to dictate the terms of the employment. The employee who is at the receiving end can hardly complain of arbitrariness in the terms and conditions of employment. This court can take judicial notice of the fact that if an employee takes initiation in questioning the terms and conditions of employment, that would cost him her job. Precisely in a more or less similar circumstances. Where is the bargaining power for the my lord persons who are seeking employment? Now, Lordship will kindly rationally, determine one concept aspect, my lord. Now, today, the government of the day, they are resorting to this contractual nature of appointment. Now, what option the citizens have, my lord, when the unemployment has gone up to 40% plus, do they have any option, my lord? Now, therefore, my lord, please recall the observation of the Supreme Court in that, my lord, Madras case, that is why I said even temporary government employee, they are entitled to protection of 311. End of the day, my lord,
Mysore case, Mysore,
no, my lord, government press,
Mysore,
Mysore,
Veliappa.
Veliappa. My lord, their Honorable Supreme Court says that Article 16 applies not only at the stage of entering into service, it applies even during service, even in respect of termination. So, my lord, we have forgotten this, my lord. My humble submission is, I as an employee, can I have a choice, my lord, that this appointment I will not undertake? When, my lord, there are 230 projects, all are, my lord, manned by regular employees. Only in respect of this 23, this advertisement was issued. My lord, an argument can also be there that many did not apply because it was for contextual employment. My lord, those have been covered in this appeals case. Now, here it says, my lord, what therefore eventually court, Honorable Supreme Court went on to decide what is a substantive appointment.
Yes.
My lord, that Government Press's case, that I think para 19 is very important, where it says, my lord, protection of Article 16 is not confined to initial entry into service. It is also confined to it also includes situation post-employment. Therefore, my humble submission is, my lord, let government consider my case. When, my lord, and second aspect is always there.
That Veliappa effectively may not help you because that is bringing in concept of 311 for an ad hoc employee.
No, temporary.
Temporary ad hoc employee. You cannot, only because he's ad hoc, will not follow 311. That has been.
At the end of the day, my lord, it boils down to the question of giving constitutional protection only. Be 311. My lord, now Supreme Court has also in one of the cases gone to the extent of saying that even if there is no requirement of natural justice, it is inherent, it is implied. For example, now in the context of this contractual appointment, power is considered to the employer to give 1 month's notice period and dispense with the employer. Honorable Supreme Court says now, no, you can't do that. A recent judgment, my lord. So, my lord,
it all depends on the facts and circumstances.
no, what I'm saying is, because of the need, my lord will appreciate, think of 80s, what was the law? No hiring and firing policy. So regularization was the order of the day. That is why Umadevi matter. There was a time in 80s, my lord, when I was CGSC, my lord, I dealt with cases where this honorable court says, no, consider their case for regularization. Because that was the time when ad hoc appointments were made. So now contractual appointment has become the order of the day. Now, the moment that a holder of a contractual appointment, what right does he have other than natural justice, which is again implicit in Article 14? So kindly see the broader picture. Now, what I'm trying to say is, the government could have regularly appointed us. Government did not. Of course, it contains a stipulation that eventually I'll have to participate in.
Why has not that regular process been done?
No, that has not been done.
Why?
I don't know.
From 2010.
Yes.
And now you have crossed your age also.
We have all exceeded the upper age limit. All. And we are working for a paltry period, sum of rupees 30,000 or something. Na? Whereas our equivalent post, they are enjoying more than 1 lakh of salary mine.
Along with other allowances.
Along with other allowances also. Mr. Chaudhary?
My lord.
Along with other allowances also.
Yes, so many other. And we do everything, my lord. Tomorrow we are called upon to COVID duty. We are called upon to do, my lord, election duty.
Just like a regular employee.
So at least, my lord, following Jagdish Singh's principle, then at least we are entitled to equal pay for equal work. So my humble submission is, my lord, yes, it is a fact there is a clause in the advertisement. Those are all there. But they can still consider.
Yes, Mr. Gogoi. Gogoi, you're for whom?
Okay, I put a pen.
Fine. Okay, yes, madam. Contractual.
I'm just reading one small paragraph. I think the book will come by then.
Of Thapial.
Thapial, para 37.
Yes, please.
It says, my lord, From the narration of facts as being referred to supra, it clearly manifests that the appellants were appointed after going through the process of selection as contemplated under so, which indeed was an appointment on substantive basis. And since the appellants were not in equal bargaining position, were in need of employment when the offer of appointment was made, were left with no option but to accept such arbitrary condition incorporated in the letter of appointment, in treating it to be contractual for a limited period, still recorded their protest while joining, but no heed was paid. When they were allowed to continue by extending their services, they remained under the bona fide belief that as their appointment is being substantive in character, they will be made permanent, confirmed immediately after permanent post was sanctioned in the department. But to their dismay, after an advertisement came to be notified by the respondent, no option was left with them but to approach the court. So when an advertisement was issued, my lord, to fill up those posts, then my lord, they approached the court and eventually Supreme Court has upheld. My lord, there are similarity of facts in this case also. I'm aware of the limitations, my lord. I'm not saying that it is an open and shut case or something. All that is, lordship will kindly consider the nature of right, my lord. That is my humble submission.
Yes, yes. Yes, madam.
Lordship, in this case, we have filed our affidavit also, Lordship.
Okay.
So I will go by the affidavit only, whatever is stated there, Lordship. Lordship, in paragraph 4 of the affidavit, Lordship.
You have 4 respondents.
Yes, Lordship. Actually, our name is not shown, Lordship. That's why we are not that prepared, Lordship. But anyway, I have been.
You are always prepared, yes.
No, Lordship.
You have filed affidavit in opposition dated
It's dated, Lordship, 3rd March 22, Lordship.
Okay.
Filed by the respondent number 2, Lord.
Okay.
Lordship, in paragraph 4, we have stated, Lordship,
Okay.
that the Assam Social Welfare Recruitment and Promotion Service Orders 1994, which stipulates that the post of direct recruitment quota of Child Development Program Officer and allied cadres shall be filled up on the recommendation of the Assam Public Service Commission. Therefore, the employees recruited on contractual basis also required to be recommended by the APSC to become eligible for regularization in service, Lordship. And here in the present case, Lordship, none of the petitioners in the petition have been recommended by the APSC for regularization of their service. Then, Lordship, paragraph 7, Lordship.
No. When you say that they have not been recommended,
Yes, Lord.
they were inducted in the year 2010 pursuant to a recruitment process which was no doubt on contractual basis.
Yes, Lord.
It gave you the power to renew based on their based on an evaluation of the duties they have performed.
Yes, Lord.
And it also stipulates that in case of regular appointment by the APSC,
Lord.
those incumbents will have to apply.
Lord.
Now, did you have a facility or a situation where they were given an opportunity to compete for those posts which they are holding on contractual basis?
Lordship, that point has not been addressed here, Lordship.
No, that is the main part.
Yes, Lord.
If one incumbent is given a post in
Yes, Lord.
place B, place A,
Yes, Lord.
that post has never been filled up on regular basis.
Yes, Lord.
You did not take any initiative to bring it within the ambit of a regular employment
Lord.
through the APSC. And the incumbent continues. There is no problem with the educational qualification or the
Lord.
duties performed, or there is also a recommendation by your director.
Lord.
That similar nature. Then regularization is one part. The other part of discrimination in the pay and allowance, that is also one part. Is there any difference in the duties performed by the petitioners and other CDPOs? There cannot be. They are manning a project. All projects
Sure.
are at par. ICDS projects, there are many
Yes, sir.
projects. They are at par. You cannot
Sure.
differentiate. This is a project of a lesser magnitude. This is of a higher magnitude. Whatever is the project, CDPO is the same.
Sure.
And there is no dispute that these petitioners are working as CDPOs.
Lord,
So if they are discharging the same duties,
Lord,
why are you making a discrimination so far as this pay is concerned? Regulation was an aspect we will consider.
Lordship.
Now, strictly speaking, we have already indicated that Umadevi they do not overcome because there was an initial stipulation
Stand we have
in
taken it. Yes,
the
Lord.
affidavit, in the
Yes.
advertisement itself, that
Yes.
for regulation you need to compete with the
Lordship,
APSC, with
this is
in
the
the APSC.
criteria.
But was
Yes.
there a process by the APSC where they had competed, failed, and by interim
Lordship.
models they are continuing? It's not like that.
Lordship, on that point, I need to take instruction, Lordship, because
that is
this
the-
point
that-
has
that-
not been addressed here in the
No, that is
affidavit,
the only
Lordship.
point ultimately we want us to
Lordship.
consider, whether this court or any other court.
Lordship.
That is the point. No, we are mainly concerned with the entry. Was it done stealthily or was it done through an open process?
Or a backdoor.
Mm,
It was done by an open process. It's a contractual, okay, contractual, doesn't matter.
yes, Lord.
They enter, then have a regular process. If they fail, they are out. But
Lord.
you do not hold a regular process till 14 years. In the meantime, much water has flown. They have become overaged.
But one thing
And
we
they
are
may not be
telling-
able to compete with young people.
Yes, Lordship. One thing that we are, Lordship, saying that the contractor cities they were not appointed according to the order, Lordship.
No,
Of the
that- that-
social welfare. Yes.
That is your action.
Yes,
You cannot condemn your own action.
Lord.
It is not a stray appointment that one person picked
Lordship.
up and appointed. You made an advertisement, people applied. And rightly so, there might have been some exigencies. So you had included the clause that for regular appointment, you have to go through APSC.
Lord.
Hold the regular appointment, let them participate. You did not do. Now, after 14 years, will it be reasonable to ask them to face an regularization process through the APSC?
Okay,
That will
Lordship,
be-
I shall appraise your Lordship on that particular point, Lordship, whether they were
Well,
given
to the
opportunity.
17th matter we have heard.
Yes, Lordship. But at least at 2 o'clock, Lordship, if possible, or I shall prefer the next week, Lordship,
Next week, this court may not be there.
or on Friday,
You
Lordship.
have to come to Kohima.
Okay.
We won't mind.
Good weather.
So, as per your convenience, as Lordship has already heard.
No, we will not make it part. If you can address tomorrow, we can give it tomorrow. Otherwise, we'll have it later. But this is the only point. You need not.
Friday.
You need
And
not.
Lordship
You
will
need not
kindly-
point or stress on the drawbacks with the
Yes,
petitioner.
Lordship.
We know what are the drawbacks, their weakness. You need not point on that. We'll take
Lordship.
care of that. You take care of your drawbacks.
Yes, Lordship. Lordship may kindly reflect this in while dictating the order.
Why
Lordship.
should we?
That
Why should we
particular
reflect? You know what instructions to get. It is not from the court.
Well, look, there was one judgment I forgot to point out. 2015-17 SCC 789.
What was that?
Yes, my lord. It speaks of, my lord, alternative mode of recruitment.
2015.
2015-17 SCC 789. Pratap Kishore Panda versus Agnisharan Das. Where under the rules, my lord, the selection was required to be made by Odisha Public Service Commission. It was not done. It was in that context, regular advertisement and all were there. I'm just reading that para 17, my lord, towards the later part. It was not a relaxation of the rule in order to favor a few, but was the consequence of following an alternative method of selection intended to remedy in the recruitment process. It is within the powers of the state to organize an alternative recruitment drive when insufficient SC/ST candidates are available, and under Article 3024 of the Constitution was not required to be consulted. Here also, according to rule, my lord, through Public Service Commission, this selection was required to be made. It was not done. So, Honorable Supreme Court says it was an alternative mode of recruitment.
That by itself will not make it illegal. In fact, that is not their case, that your appointments are illegal.
Yes. The only thing is, my lord, we having undergone some process,
Hmm.
We have been continued for such a long time.
Yes.
Now, at this stage, where will you go? That is the only thing.
Lordship, I pray the Friday, Lordship, take up the
We'll
matter.
try on Friday.
Yes.
Yes, Lord.
Third, Sri K. N. Chaudhary, Learned Senior Counsel for the petitioners. Para. Sri MS M. Bhattacharya. Learned
Okay.
Additional Senior Law Advocate, however,
No.
prays for a little accommodation to take appropriate instructions. Full stop. Well, Friday we'll try, otherwise we'll have a,
Yes, but-
this needs to be,
Or when your Lordship sits next,
okay, list on,
20, a day after tomorrow,
yes,
deep dive.
17th.
Full law. 17.
17th, day after tomorrow. Also messed up here. Sure.
Lordship, as per the last order, I have received the instructions, Lordship, so I want to file an affidavit.
Are the petitioners interested? What is the issue involved, madam?
Declaration, Lordship.
None appears for the petitioner on call. Full
Last
stop.
occasion
On the last two occasions, that is 26/11/2021 and 16/2/2024. There were no representations from the petitioners. Para? Ms. D. Boralan, Standing Counsel, Health Department is however present. Full stop. Para? In the interest of justice, a further opportunity is granted to the petitioner. Full stop. List on 17/5/2024. Full stop. It is however made clear that in case there is further non-representation on behalf of the petitioners, appropriate orders would be passed. If they appear, we'll grant you time, otherwise we will not
Okay.
continue with this.
Please, Lord. My Lord. Now, my Lord, I have limited prayer, my Lord. Already, my Lord, during the pendency of the petition, my Lord, I have been promoted.
As,
And the private respondent, my Lord,
as promoted as what?
my Lord, superintendent, my Lord,
Of?
APSC office, my Lord, Office of the Assam Public Service Commission,
Okay, you are an employee of the APSC.
my Lord,
You have been promoted as superintendent
my
now,
Lord. From the senior assistant, my Lord, received
from senior assistant.
senior assistant, my Lord. Now, my Lord, the private respondent who was promoted to me, my Lord, superseding me, my Lord, he also retired, my Lord. Now, my Lord, the seniority is not, my Lord, dispute. Only thing, my Lord, remain, my Lord, part where, my Lord, 8 months is different, my Lord. That part is only remain, my Lord. She was promoted on, my Lord, the professor was promoted on 8/5/8/17, my Lord.
5/8/17.
Annexer, my Lord, page 32, my
Private
Lord,
respondent number
4, my Lord.
promoted as superintendent.
My Lord, Srimati Sushma Das.
Promoted as superintendent.
My Lord, my Lord.
Yes.
My Lord, this the order is, my Lord, page 32, my Lord.
And you were promoted when?
I was promoted on, my Lord, 21st to 2018, my Lord.
18.
18, my lord.
Petitioner also promoted.
My lord.
Okay. Now what is the remaining issue?
Issue only that, my lord, that I should have been promoted from the date of promotion to the, my lord, private respondent, my lord. Except that, my lord, seniority was still retired, my lord, by 20, my lord. So my seniority is not disputed, my lord.
2020 R4 retired.
My lord.
And your retirement date?
My lord, 26.
2026 petitioners. Yes, Mr. Datta?
That can submit a representation for the commission, so it considered.
No, no. Was there any discrepancy or anomaly in the initial promotion of the private respondent number 4 in the year 2017, from which date the petitioner is making a claim? Was his claim, is his claim justified?
In my humble submission, no, Lord.
He says that the respondent number 4 was junior to him.
My lord, otherwise junior, my
Yeah,
lord.
the roster, he was promoted by application of roster reservation. He is a STH claiming. STH claiming come under roster point 14.
He is STH.
STH he is claiming. Initially, he was appointed as STP. That on his class was converted lordship by the order of the government lord. So if he
Petitioner is STP.
initially was appointed as STP,
Now STH.
STH, if he is to slotted
Initially,
14 lordship,
initially your petitioner appointed as STP.
P lordship. He was Lalung belongs to Karbi Anglong.
STP. Later, government changed to STH.
By presidential order, my lord, it has been included in the STH, my lord, that community in the hills, my lord. Karbilang and Castle Hill by 2008.
Or earlier it was STP.
STP.
Oh, there was a change not by you, by the
By
presidential
the
order of
constitutional
1950.
presidential order, my lord.
1950 order.
My lord.
There was a change.
My lord. Then
Oh.
I have been promoted junior administrative assistant to senior by as an STH, my lord.
Okay.
Thereafter, during when my promotion came, my lord, they have treated me STP, my lord. That's why the other private respondent is promoted in the, my lord, post of my lord.
Private respondent is of which?
Otherwise, he is junior to me,
Which
my
is which community?
lord. The SC, my lord.
SC.
SC, scheduled caste.
SC will have a different roster.
Different roster. Roster point 5. 8.
No, that roster point is STH, my lord. Because I was treated as a, my lord, STP.
No.
That's why I was not promoted.
No, if the private respondent would have been an STH,
My lord.
which you have later become, matter would have been different. You are at par.
My lord.
Now the private respondent belongs to a different community.
My lord.
SC, which
My
has got a different roster point in the 100-point roster.
My lord, this is 13, my lord, 12 post, this is the 13-point roster will come, my lord.
Yes, 13th is what?
My lord, lordship, I have annexed that.
6 of my affidavit of opposition.
13th is what?
My lord, that schedule to roster, my lord.
Yes, 13th point will be what
The
community?
14 point is for the STPH, my lord.
13th, he said 13 will come.
So, no, my lord, when there is a 13, less than 13 or 13, my lord, that schedule 2 is coming, my lord, coming into play, not the 100-point roster, my lord. Lordship, I have annexed page 31, annexed 6.
Seventeen to August to hardly 8 months.
My lord, only that, my lord, financial benefit difference is there. Otherwise, my lord, the seniority, my lord, he has retired now, still I am senior, my lord.
Okay.
That is not.
Let us close this. Will not make much of a difference. Okay. You have filed affidavit, Mr.
Lordship.
Doctor.
So the 3 vacancies were lordship arranged. Out of the 2 were backlog and 1 meant for STL.
Okay. Heard. Sri M. Saranya, Learned Counsel for the petitioner. Also heard. Sri P.P. Datta, Learned Counsel, Standing Counsel for the APSC, respondent number 1. APSC for the respondent numbers 1 and 2.
1 and 2.
And Ms. M. Bhattacharya, Learned Additional Senior Government Advocate for respondent number 3. Anyone appearing for 4?
4 is
Under appeared, my lord. I think he retired, that's why.
None appears for the respondent number 4. Full stop. Para. At the outset, comma, Sri Saranya, the learned counsel for the petitioner, has fairly submitted that during the pendency of this writ petition, comma, the substantial relief of promotion to the post of superintendent in the APSC has already been granted to the petitioner. Full stop. The present issue is only with regard to a claim for benefits from the date when the respondent number 4 was promoted to the post of superintendent
Right.
in the commission. Full stop. Para. Bereft of details, comma, it is projected that the petitioner was senior to the respondent number 4 in the feeder cadre of senior assistant
My lord.
in the commission. Full stop. However, the respondent number 4 was given the benefit of promotion to the next higher post of superintendent on 5/8/2017 by overlooking the case of the petitioner. Full stop. It has been projected in the petition that both on the count of seniority as well as roster point, comma, it is the petitioner who should have been given the benefit of promotion prior to the respondent number 4. Full stop. It is also submitted that the justifications ought to be given by the commission, which by taking the support of the roster point is also an incorrect justification. Full stop. It is clarified that though the petitioner was initially appointed as an STP, comma, his community was brought into the STH
ST, my lord.
category
Category.
by in the presidential order of 1950
By
and
amendment
for-
of 2023.
by an amendment of 2003, and because of the said amendment, comma, prejudice could not have been caused to the petitioner. Full stop. Para. Sri Datta, the learned counsel for the APSC, has however submitted that seniority was not the criteria. It was not the only criteria, and the promotion of the respondent number 4 to the post of superintendent was done by following the roster point.
Okay. ST.
Full stop. It is submitted that the said respondent number 4 is a scheduled caste candidate, and the roster point 8 was meant for scheduled caste, which is a different category from either the STP or STH, whichever community the petitioner may be treated to belong.
But this is not correct position.
Full stop.
So this is the correct. Page 38.
It is para. Sri Saranya, the learned counsel for the petitioner in his rejoinder, has denied the correctness of the submission regarding the category of the private respondent number 4 vis-a-vis the petitioner. Full stop. Para. This court has, however, been informed that the respondent number 4 has also retired from service on attaining the age of superannuation in the year 2020
31st 3, 2020.
on 31/3/2020. And therefore, the aspect of seniority is no longer an existing issue. Full stop. As regards the only issue which may be treated to be alive is the period of benefit from 5/8/2017 to 21/2/2018. Full stop. Apart from the aforesaid period being of about 6 months only, and there being a dispute and the claim of the petitioner to have been given the benefit of promotion on the same date being disputed on the ground of the restore point, this court is of the view that the said issue, that the said claim of the petitioner is not a substantial claim which requires a further examination. Full stop. This court has also taken into note that the petitioner who was promoted on 21/12/2018 as superintendent has his service up to 2026. Full stop. Para. In view of the above, no effective relief can be granted to the petitioner, and accordingly, the writ petition is closed.
Apply.
Failure represents my lord to consider by the department, my lord.
Well, don't open it again. Close it. If you have anything, we can ask. Have that.
My lord, mind the second prayer I prayed with effect from that of my lord promotion of the private respondent, my
Let all things come to an end. Even good things has to come to an end.
lord.
Item 6.
Mayor, please, Your Lord.
Yes.
We're supposed to take instruction regarding post.
Upon our letter, the deputy president found out in regard to not providing of appointment letter to him, Lordship, although that criminal case he was been acquitted from the Lordship, till now, Lordship, success are awaited. So, Lordship, may kindly give me some accounts so that I can pay.
What was the Gaubura?
Appointment account.
Verify today.
Although there is a appellate provision under the revenue authority, Lordship, the commission under the, but thing is that perhaps from the petition, there is no such order by the deputy commissioner.
Metropolitan Election. No, was any appointment done?
Not, my lord. Of late, I don't have instruction, Lord. They may.
No, that's not perfect.
In 2018 itself, 2 weeks was given to them to get that, my lord. It's 6
No,
years.
see here, even if we come to a finding
Yes.
that a case is made out,
Yes.
then in absence of a challenge to the new appointment,
Yes.
we may not be able to grant you any relief. But yes, we may make some observation by which you can seek compensation against the
Yes.
erring persons. Because it appears that you were selected, criminal case filed, you claim that you were acquitted in the criminal
Yes,
case.
And immediately I have filed representation.
And
of-
that would be a very dangerous precedent. Any appointment only by filing a criminal case, if it is affected adversely, then every appointment will be somebody with any oblique intention can halt it.
And officially, they can take the instruction.
Why,
of the-
what is the problem? Of a particular village, Gandhia village, part 3 in
Yes.
district of Nalbari, Gaubura appointment, was it
In
done?
the Lordship, this minutes of meeting, where he was being selected. Last thing, it has been mentioned that appointment will be made on receipt of satisfactory police verification report and physical fitness report from the health authority. That was the condition. That's the page number 30.
Mr. Sharma Bora, that is one aspect. We want the other aspect, whether this particular post has been filled up or not. That is a very simple instruction. One telephonic instruction.
Yes, ma'am.
Call him, he'll make an inquiry from the concerned.
Absolutely. And we have to be sure that whether any order has been passed.
If the post is still vacant, then we effectively adjudicate. If the post is still not vacant, then there is no point adjudicating. We can make some other observations.
Then there is the
What is your age?
Which, my lord, presently, my lord. Uh, 37, 36.
37, 36,
36.
2018.
Yes, my. 31. Now 36.
Or now 36. Still he
Yes.
has a chance.
31, yes. ma'am.
Do this court by the order dated 6/5/2024 had granted time to the Learned State Council to obtain instructions on the issue involved, comma. Sri C.K. Sharma Bora, Learned State Council, prays for some more time. Full stop para. Considering the issue, a gist of which has also been reflected in the last order dated 6/5/2024. And also the fact that the writ petition is pending since 2018, comma, a final opportunity is granted to enable the Learned State Council to obtain instructions. Full stop. Instructions are also to be obtained on the aspect regarding the vacancy in question, whether it is still existing or filled up in any recruitment process. Full stop para. List. We'll have it on Friday next. We'll grant you adequate time. Get it immediately on 24th is a working day. Yes. 24th. Plus 23rd day one also. 24th.
first one.
24/5.
7 to 9.
Please, Your Honor, to kindly madam take up at 2.
2 o'clock. Why? What is the, who's there?
B question.
Okay. What is the matter?
The matter is to promotion to the FSL lordship to the post of deputy director.
Two petitioners.
There are 3 cases there. I am in item number 7.
Gogoi for 7. What about 8? Sharma for 8.
3 for
8 and 9. You are all similarly placed.
yes, sir.
You are challenging what? Challenging what? You
Next, we have been promoted to next target on time. Sir.
you are in which post now?
So now I am senior scientific officer.
Junior scientific officer.
Senior scientific right now.
Senior scientific officer. And you want to be promoted to which post?
Deputy director.
Deputy director.
In
Post.
the year 2018. Now I came for join back.
Now you have been already appointed as promoted as deputy director.
No, not yet.
Then why now joint director?
If still the tenure of service, then I am eligible for join back. Right now.
Okay. Are those posts vacant?
Yes, sir.
Posts are vacant.
Yes, sir.
Oh.
Eligible to belay.
Mr. Datta, what is this? You have a role, no? Oh. Okay, we'll have it at 2 o'clock.
Next week.
By 2 o'clock difficulty, these are old matters.
On the next week, Lordship, on Friday or next week. I have some clear left to approach.
Come at around 12:30.
Sure.
12:30.
Okay.
12:30 is okay?
Okay.
Okay. Second half will not take, but 12:30 will try.
I love it. Much of it.
It is sorry, but I'm not to do. Mr. Mahmood for
I
respondent.
am for private respondent number 5.
Ardhor.
Lordship, I am.
Actually, my lord, if your lordship kindly permits me,
Yes, yes.
there is no case at all.
There is
Kindly
case.
see, let me
There
start
is
it
case.
first. Page 17 kindly see. Page 17.
Yes.
This is the advertisement, who is the claim. But that has been replaced by another advertisement. Now that is.
That
no
is
longer-
what, that is what we are before your Lordship.
So it is now HS pass is required. She is HSLC. So she has no qualification even to become a candidate
For what? For
for
recruitment
the
for?
post of Anganwadi worker.
Now higher secondary is required.
Ah,
Yeah,
higher
yeah,
secondary.
You are
He is-
challenging that.
That Lordship.
Okay.
No, he has
Because
not challenged that.
Lordship, if your
He has
Lordship
not
comes
challenged that.
to page 27.
Okay, let us listen to.
If your Lordship comes to page 27 for a moment, that will, it is the actual piece, Lordship.
27.
27. It is from directed to the Child Development Project Officer Office.
You are an
2nd March 2019. May I read, Lordship? With reference to the subject cited above, I would like to inform you that the proposal for approval of merit list for selection of Anganwadi worker in 330 Kajagai Point AWC under your project could not be approved as it appears from the merit list and comparative statement that the selection was not done strictly on the basis of the marks obtained in HSLC examination, which was also mentioned in the advertisement published by your office by number dated 31st May 2018. Therefore, you are asked to initiate press selection. Why Lordship press selection? Because my mark was 45 in the HSLC and the private respondent secured only 33. Therefore, press selection cannot be, Lordship. They should have press considered my case, Lordship.
Now, what is the requirement? HSLC or
Earlier it was HSLC.
no, during this time, 2019.
It became HS.
It is higher secondary.
Higher secondary, Lordship.
Then
Lordship, prior to that selection was defective. Lordship, director has stated that comparative statement of the selection was not done strictly on the basis of marks obtained. My mark is, Lordship, if I take your Lordship to my mark,
are you a higher secondary pass?
No, earlier HSLC pass.
Are you higher secondary?
No.
What is the requirement?
Now it is the HSLC.
No, not now.
Earlier.
2019.
HSLC pass.
2019, it is the
Page 30.
page 20, 31st May 2018, it was the earlier advertisement where
Higher secondary was
No.
required.
HS part.
High school, HSLC pass.
HSLC part.
Page,
Page 17, it starts from page 17 and the operative portion of Lordship, that page 18C. Page 18C.
page 18.
18, serial number C. The
Yeah.
candidate should have the qualification of HSLC, AHM examination passed from the Board of Secondary Education Assam or equivalent examination from the recognized board by the
Okay.
government of Assam. In case
This was the
there is-
advertisement.
Lordship.
Advertisement.
This is the advertisement.
31/8,
31.
31/5, 18.
18.
Advertisement.
Advertisement.
HSLC required.
This is very good. This
You
was
are
the
you
requirement.
are a matriculate,
Yes,
HSLC. And private respondent is also matriculate.
No.
Private
HSLC
respondent might have.
You are higher
higher
secondary.
secondary.
Now, while what has happened, both of you had participated.
Lordship,
Then what happened?
it was selection.
Mr. Mahmood is ASPA number
5.
R5.
Selection should have been done on the basis of the marks obtained in the HSLC.
Hmm.
I secured 45% mark, Lordship, an extra 5, 4,
Secure?
plus 25.
Secure 45%.
Yes, Lordship.
And you are very proud of 45%.
And the private respondent secured 33%.
Comparatively, you are proud.
Yes, Lordship. Because I am 45 and she is 33.
If you have reasons to be proud, even Mr. Mahmood has reasons to be proud. 33 is pass.
33 pass. And 45 is second division.
What
33
is
is third
important is
division.
whether you have passed or failed.
33 is third division. 45 is second division, Lord.
45 is second division.
Yes. Because certificate will,
My
certificate
learned
will speak,
friend
Lordship.
is not challenging that advertisement. Kindly see his prayer. Page 11.
Okay, R5 got 33
Yes,
in HSLC.
HSLC.
And marks were not granted in terms of the
Yes.
marks obtained in
Oh,
that is your
HSLC.
case.
This is my case.
Okay.
Therefore,
And-
subsequent advertisement is absolutely illegal, Lordship.
Even otherwise also she is not eligible. If
We'll come to you.
exam
We'll come to you. We'll hear the government. Then now that advertisement was not finalized.
Not finalized. No.
Then second advertisement came.
Second
When?
advertisement.
When?
Second advertisement was published on 25 January 2019.
Page
Page 30.
30.
30.
Okay, let us see 30.
If the selection was not done in conformity with the procedures,
Now that post has been filled up.
that I am not aware of in my learned friend can.
Mr. Mahmood, 4 posts filled up
was filled up by me
later
But,
on. Later on.
later on. But thereafter also I have been also ousted.
Terminated.
Ousted. But the thing is this, my lord.
Your
My
ouster,
lord-
your ouster is the subject matter of challenge in any petition? No.
No, and yes, there is separate petition. It
By
is
filed by you.
Separate, yes.
So what is there to
But
decide?
one thing is, my lord,
Lordship, if your lordship
My
comes to,
learned friend
again,
has-
lordship, page 27.
No, we have
Why?
paid.
What
No.
what was the requirement of issuing the
Mr.
second
Dhar,
advertisement?
Mr. Dhar, we are not denying your case, but because of the subsequent development, where an incumbent has been appointed, she has been removed, litigation is on, what right will you have?
Let that matter come up with this matter, lordship.
After a removal, somebody else has been appointed.
no,
It's still lying vacant.
lying
Post of
vacant now lying vacant.
Anganwadi worker post vacant. Why?
Perhaps they are managing through other process. My lord, one thing lordship would see, my learned friend has not annexed the selection list. But I have the selection list. In my petition, MP20 petition that is there, Leelavati Gwala, I am Leelavati Gwala, experience based in personality test and acceptable. And this Lakhirani Gwala pregnant, 4 in personality test. So at that time she was pregnant.
Mr. Dhar, there is no interim order. What relief can we grant here? Post has been filled up. That's a separate cause of action that he is espousing. He has been removed.
He has also not challenged the subsequent advertisement.
This will not, we cannot grant you any effective
Nothing
relief.
is there in case. He has not challenged-
Madam Bhattacharya, what is the status? But Mr. Mahmood has very fairly said that he was appointed, but
Yes.
his appointment is also been, okay, Mr. Mahmood, can you give your petition number?
That number. My lord, I will provide you at 2 p.m. My lord, I will.
Please provide it. We'll close this.
Yes. I will.
Heard Sri R. Dhar, learned counsel for the petitioner. First of all, also heard Miss M. Bhattacharya, learned senior advocate Assam. Full stop. Sri M. U. Mahmood, learned counsel, has appeared for the respondent number 5, who has also filed affidavit in opposition on 23/7/2019. Full stop. Para. please have your seat. The controversy raised, have your seat, please, raised in this writ petition is with regard to a recruitment process to the post of Anganwadi worker in the 330 number Kazidadhar, whatever we call Kazidahar Point, Anganwadi Center. Full stop. Para. Shri Dhar, the learned counsel for the petitioner, has submitted that the advertisement was made on 31/5/2018 for filling up of the aforesaid post, in which the stipulation regarding educational qualification was HSLC. Full stop. It is the categorical case that of the petitioner that while the petitioner had secured 45 marks, 45% marks in the HSLC, comma, the respondent 5 had secured 33%. Full stop. However, without offering the appointment to the petitioner on the basis of such assessment and evaluation, comma, the respondent authorities had issued a fresh advertisement dated 25/1/2019, wherein the minimum qualification was enhanced to higher secondary. Full stop. It is the submission of the learned counsel for the petitioner that the rules which had existed at the time of recruitment should be followed, and there is no dispute that when the recruitment drive was initiated, while the advertisement dated 31/5/2018, comma, the minimum qualification was HSLC, and marks and assessment was to be made on the basis of the marks secured by the candidates appearing for the said recruitment process. Full stop. Under those circumstances, comma, it is the contention of the petitioner that the second advertisement dated 25/1/2019 is not sustainable, and appropriate directions are to be issued requiring appointment of the petitioner as Anganwadi worker in the aforesaid Anganwadi center. For the para. Ms. M. Bhattacharya, learned State Council, has however submitted that the minimum qualification was enhanced to higher secondary, which is not the subject matter of challenge, and therefore the second advertisement prescribing such minimum qualification cannot be subject matter, cannot be challenged by the petitioner. Full stop. Para. Sri Mahmood, the learned counsel for the respondent number 5, has submitted that due to the development which has taken place, comma, the writ petition itself is not maintainable. Full stop. He submits that though the petitioner might have secured more marks than the respondent number 5 in the HSLC, comma, the same would not be relevant in as much as the requirement,
This is the merit pay.
the requirement, the eligibility requirement is higher secondary, which would be evident from the second advertisement dated 25/1/2019. Full stop. He has further informed this court that pursuant to the second advertisement dated 25/1/2019, comma, the respondent number 5 was selected.
No, as per earlier advertisement, 18 advertisement I have been selected.
And 19,
19, that is, as 19 has come, so I have been also.
he has informed that that respondent number 5 was selected, who, however, has also been discontinued after issuance of the second advertisement. And therefore, there cannot be an effective adjudication of the issue involved in this case. Full stop, para. After hearing the learned counsel for the parties and on perusal of the materials on record, comma, this court is of the considered view that this court has noticed that though this writ petition is pending since the year 2019, comma, there is no interim order. Full stop. This court has also been apprised of the subsequent development of appointment of the respondent number 5 and also her discontinuation, which has been stated to be the subject matter of a challenge in a writ petition filed by the said respondent number 5.
I will provide.
Full stop, para. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that no effective relief can be granted to the petitioner at this stage, as the announcement of the eligibility criteria requiring higher secondary is not the subject matter of challenge. Full stop, para. Writ petition is accordingly closed. Okay.
Obliged, sir.
You give the number, we'll
Yes, but I
incorporate.
will- Before 2, I am providing.
The number to the WPC to whom I given, otherwise not. Yes. Yes, Mr. Das.
Doctor, this is pertaining to selection and appointment to the post of Kangura. Doctor, initially, it was me who was selected. After publication of the select list, they issued another code agenda wherein my name has been replaced by the respondent numbers 7.
Okay.
Thereafter, because of lot of complaints, all the 4 members of the selection committee, Taibur Rahman, AK Elias Ahmed, and Atika Sultana, who is the DTC, and another incumbent, they were all arrested. And in the CM Vigilance case has filed 4 search sheets. And they have also filed supplementary search sheet. In the supplementary search sheet also, it has been proved that they have taken some 7 to 8 lakhs from all the candidates. Now, this honorable court, after a lot of deliberations, on earlier occasion, on 12/12/2022, has directed why appropriate orders should not be passed for interfering with the selection illegally made by the selection committee, which that resulted in search sheet being filed against the committee member.
Okay.
Thereafter, another order was passed.
This is Dhubri district.
South Salman Manka.
South Salman Manka, okay.
Thereafter, another order was passed on 19/12/2022. Commissioner Lower Assam to show cause as to why appropriate orders could not be passed for interfering with the selection. Thereafter, another order was passed, government to produce the relevant file note sheet by which the process of issuance of corrigendum was instituted. Lordship, on the earlier occasion, Lordship, they have all the records from the CMS vigilance sale, and the record was prepared, and this honorable court also asked them to show me the records. And from the records, Lordship, I have detected. In fact, Lordship, corrigendum was issued on 14/6/2018. And Lordship, as just the first list is a genuine list, and the select list was published on 9/10/2018. So there was, while they have issued the corrigendum on the same day, there was no any minus, no corrigendum. And on the last occasion, the government, from the government advocate, they have admitted that there is no such minus. They have simply issued this corrigendum only because of extraneous consideration. So from the file sheet, Lordship, I have noted down, Lordship, because the original records was produced before this honorable court. And Lordship, selection committee consisted of 4 members, but only 3 members have given the mark. And no
Now,
date.
what is your existing prayer now?
My prayer is, Lordship, I should be appointed as a, in view of the select list, wherein Lordship, my name appeared, I should be appointed as a town Pradhan. In Lordship, plot number 12, Himpara Revenue Village, under Mangasar Revenue Sir. Lordship, may kindly see the select
Yes,
list.
who's appearing, Mr. Mohanta
My
for?
lord, your lordship, kindly see what is there.
But you're for
I am for the private respondent, my lord. There is little difference
private
in the,
respondent means selected candidate.
my lord. He also, my lord, your lordship, kindly see page 47. Page 40, everything will be clear.
And
Page
madam, what do you say?
No. No, record was produced before this honorable court, and he was inspected also, my lord. Nothing has been found anything wrong, my lord. Your lordship, kindly say only, my lord, name difference. His name was wrongly appeared. He is Nurul Islam Ahmed instead of Nurul Islam Sheikh. So I am Nurul Islam Sheikh, and he is, my lord, I am Nurul Islam Sheikh. He is Nurul Islam Ahmed. So wrongly.
Father's name, roll number.
Yes, your lordship, kindly see that.
Roll number.
Your lordship, kindly see page 47, kindly see that. Page 47. So immediately after half an hour, my lord, corrigendum was issued.
No, he says that records would indicate that the corrigendum is not based on any minutes.
My lord,
Corrigendum is not backed by any minutes that you need to issue a corrigendum
My
because
lord.
of.
That, my lord, that will be answered by, my lord, Deputy Commissioner.
No, if and the other factors which will also be relevant, that criminal cases were filed, not
No,
only
there,
filed.
my lord, your lordship, kindly see, I have filed an application for vacating stay, my lord. On that day, my lord, there is intention of the court that, my lord, you produce the mark, who have obtained mark. What? On the basis of the mark, my lord, they will be decided. So mark, my lord, it was produced before this honorable court. My lord, I am getting higher mark than him, my lord. So that is my admitted position.
How much marks?
My lord.
No, are you trying to contend that in spite of all these anomalies, if you go
No,
to the marriage,
anomalies, my lord.
listen to us. If you go to the marriage, irrespective of the anomalies, the actual fact is that you got more marks than him.
My lord.
And there was some discrepancy in the name.
My lord.
And therefore his name was wrongly given in the first list. And therefore in the corrigendum, it was corrected. That
My
is your
lord.
case.
That is my case.
And to get support, you said that you are still open for inspecting the marks. If he has got more marks, he is the first. Otherwise, you are the
No, that
first.
is disclosed, my lord. He admitted, my lord. That is your lordship, kindly see.
What do you say?
His fare is also that, my lord, on the basis
Mr.
of the
Das,
mark.
as we have just indicated, anomalies is one part, very serious. But ultimately, if we go to the marks given to the respective candidates, and we find that the marks given to your client is less than what was given to Mr. Mohanta's client, then do you still have a case for appointment? Are you disputing with the marks? You are not disputing.
Because
You said that the initial minutes you were there
Right.
and it was changed by a corrigendum, somebody else's name was there. Their version is that yes, there has been many subsequently some manipulations are there, but there was a mistake in your name and that was corrected by the corrigendum.
Lordship, mistake in my name, not only because my father's name is different. All things are
What
different.
is your name?
My name is Nurul Islam Ahmed. My father's name is Abdul Aziz Asghar.
Just a minute, please.
Page 47.
Nurul
Islam.
Nurul
Ahmed.
Islam Ahmed.
petitioner. The father,
Father
son of
Abdul Aziz Asghar.
Abdul
Aziz Asghar.
Aziz Sheikh, SK. Okay. You have a roll number?
Yes. Roll number, yes. I have an extra.
Please give your roll number.
No, rule number in order, selection list, my lord, rule number is not there.
Roll number,
Page 47, rule number is not there. Order past five.
roll number,
It was a list published with the deputy commissioner on 19 July,
What is
2019.
your name?
his
Mr.
name is
Mahanta?
Dr.
My
Nurul
name,
Islam
my
Sheikh.
lord,
Your R what?
Page 53, my lord, Nurul Islam.
R what? Respondent what?
R7.
R7.
Son of
Just a minute, just a minute. Nurul Islam?
Sheikh. Page 50.
Page 47, where are you?
No, page 47, my lord, that is meaning, that has been corrected by issuing a correction. Page 47, his name is appeared, and page 57, 53, my name is appeared.
50?
53, my lord.
53.
Same.
Nurul Islam Sheikh.
Page, my lord,
Son of?
serial number 12. There is a correction number issued, my lord, in respect of other.
Son of Gogan Bepari.
Himpara, lot number 12.
Now, why this corrigendum? His entire details was stated.
Yes.
Nurul Islam Ahmed, Abdul Aziz Sheikh, Bhimpara. You are Nurul Islam Sheikh, son of Gogan Bepari. You are different. Your names are also different. Corrigendum has to be there because of substantial mistake in putting the name.
No, your lordship kindly see what they have stated, my lord, in the order, my lord. Page 53, my lord.
Yes.
In substance of the earlier order issued that is 2020, out of some clerical mistake correction against the slot number 11, lot number 12, lot number 35, lot number 37, and lot number 66. Is lot, my lord. Others are remain same, my lord. Only this.
What is the basis of this corrigendum?
My lord,
That will clarify everything. Madam. Mr. Mahanta may be absolutely right that there was a mistake. But you show us the one mistake. That is all.
Right, Lordship, this is the corrigendum that has been issued, Lordship.
Yes.
But as the recorder part, because all have been seized, Lordship, that's why we have got a certified photocopy only.
Doesn't
Lordship.
matter. You just tell us the basis of the corrigendum. Why was the corrigendum issued? And both are of the same date.
Same
date.
9 July.
9 days.
Lordship, when the record was produced, Lordship,
Just a minute, just a minute. Yes, basis same date. Do you have anything about the marks secured?
Its marks is different, Lord.
How much mark?
Marks is different, 1.33 marks difference, Lord. This is here.
1.33.
Yes,
Petitioner secured how much?
30, Lordship, and now selected candidate 31.33, Lord.
Say petitioner secured 30.
Yes,
R7,
31.33.
what about the appointments of the other Gaon Buraj?
In respect of two other petitioners, okay. There are three individual cases.
But because of my lord, take my lord, we are not in, I am not in appointed, and very interesting, I am going to be retired my lord after 9 months. Because nowadays, the age is my lord. I am not. It's under.
Marks obtained is more.
Marks may be more, but in the qualifying examination also, I am high secondary pass. Is private response is a metric pass.
Now, what is the
And
requirement?
because
What is the requirement?
HSLC.
HSL. And Lordship, so many anomalies I have brought on record, Lordship, the search sheet being filed. Whereas here,
No, no,
clearance
see,
clear.
if on the basis of the anomaly which you are trying to highlight,
Look.
if the government had taken a conscious decision to do away with the process or cancel the entire process, matter would have been different. And rather to the contrary, this recruitment process was for a number of lots. And except two, others have been filled up, made by the same committee.
Lordship, the entire Lordship, this still is under challenge in a separate writ petition. Lordship.
That can
That is
be-
also pending.
That is a different matter, but here, in this passing any orders after we are being apprised of
Since
the
there are
marks.
repeated orders passed by the honorable court, asking them to produce the minutes of the meeting, wherein what prompted them from issuing this corrigendum. They could not show. So it suggests that they simply issued this corrigendum only because of extraneous consideration. Because
No,
earlier it
no,
was
no,
me who was
explain-
selected.
if this marks were not there, matter would have been different. Marks are there.
Marks they have brought from the CM, already all entire record has been seized by the CM vigilance tape. And Lordship, in fact, Lordship, when the certificate copies of the records was produced, Lordship, the corrigendum was prepared on 14/6/2018. So Lordship, the first list will be a valid list, which was published on 9/10/2018.
No, the valid list has to be in commensurate with the marks obtained by you and the vis-a-vis the.
And even Lordship, the mark, the selection committee consists of 4 members. Only 3 members have given the mark. That is also an illegality. And there is no date mentioned in the neatly compiled selection list. Lordship. That was done subsequently. These things have been done.
That difficult for us to.
Here, speak, my lord, appointment wage, my lord, not been.
That is
done-
another
done.
thing, because here is a case, Lordship, wherein there is an interim order and repeatedly this honorable court extended in the interim order.
Interim
Because
order
the court is
regarding-
of prima facie view, Lordship, yes, that is an illegality.
The interim order regarding what? Not to fill up.
Not to fill up, yes.
Now, that interim order was passed after, without not being apprised of the marks secured. Now the marks are there before us.
That was,
Where is the, your contention, how do you support your contention regarding your committee?
Committee, yes. Lordship, may kindly come to page,
Take your time. It's fine. There's nothing.
Yes.
page 90,
90.
90.
Yes. 90.
90.
Yes.
During investigation, it is found that 70 numbers of candidates.
Which paragraph?
Lordship, this is a running page.
No, 90,
90, Lordship, this is a search sheet, Lordship, 17.11.
17.11.
17.10.
10.
Sure.
Yes.
During investigation, it is found that 70 numbers of candidates for the post of Gaonbora were selected for the Manchester revenue. A corrigendum of list of candidates was also issued.
No, we are not on that. You say that there
Yes,
are
4 members. Yes.
Yes.
I'm coming to.
Please show us that.
The lot-wise proposals were prepared by 17.12. The lot-wise list of proposals were prepared by Bikram Aditya Bora for the Manchester Revenue Circle and A.K. Ilyas and Ahmed for the South Salmara Revenue Circle. Mrs. Atika Sultana, the deed and DC South Salmar Manchester and the other board members selected the Gaonbora against other lots and not as per the proposal list. Each lot was prepared considering a cluster of 6-7 revenue villages, and the village headmen who were appointed by the accused persons against the state does not come under the jurisdiction of the state law. And some names of the villages are non-existent as per the village list submitted by the Office of the Deputy Commissioner, South Salmara.
Yes.
Now, we will find.
Is there anything to do with this the lot number 12? Anything in the chart sheet?
This is only a chart sheet in respect of Vikram Aditya Bora and Lordship Elias Nasim Ahmed. Lordship, they earlier filed charge sheet against Cyber Rahman. And for Atiqa Sultana, Lordship, they have filed an
No,
supplementary
this, see, this is whatever is in record, we'll go by those. Is there anything regarding block
Lordship,
number 12?
so the selection committee consists of 4 members.
Where,
and-
who is the fourth? Who is the fourth?
From the petition itself was that. Lordship will also find at page 167.
167.
17.09. Uh, 17.07 and 17.09. It is an admitted fact, Lordship, there are 4 members.
167.
Yes. Atiqa Sultana, Cyber Rahman, AK Elias Ahmed, and Vikram Aditya Bora.
Where 167?
17.07 and 17.09.
Cyber Rahman.
4% there,
Atiqa,
issue of the
Vikram.
time.
Atiqa is, Ilyas Ahmed. This Ilyas and Ahmed name is not there.
And even page 175, 171, what is the finding? From the evoked facts and circumstances, a prima facie case is well established against Vikram Aditya Bora, Deed and Circle Officer, Manchester Revenue Circle, come member of the selection board, and Abu Khair Ilyas Nasim Ahmed, Deed and Circle Officer, South Kalmara, Manchester Revenue Circle, come member of the selection board, for selection of Gambara by violating the rules and procedures by taking huge amount of gratification under section so and so of the Prevention of Corruption Amendment Act 2018. I therefore submit charge sheet against FIR named against accused persons, namely so and.
Yes, what
And
did
Lordship,
you say?
and Lordship, on earlier occasion, Lordship, this honorable court had asked a specific question. Suppose if this honorable court opposes the selection of the respondent number 7, then it would be a certificate from this honorable court, and they will produce it before the trial court. That my appointment has been held to be valid by the honorable High Court. So they want.
No, that is not a relevant proposition.
That was
will not agree with that. This is on different aspect altogether. Criminal matters are different aspects.
That is true, but it will be a certificate before the trial court. That is the query by this honorable court also.
Madam, see, only because the entire process is not a subject matter of challenge,
Yes, sir.
we will treat this in the same manner. That may not be a correct proposition. Somebody has challenged, we have to treat his challenge. Others you have upheld or there was no challenge. But for that may not be a very relevant factor for not examining the case of the petitioner. Materials on record suggest that there are very serious anomalies. criminal cases prosecution sanction granted against all 4 officers.
It's not. This will take good thought, and this, whatever statement that has been made by some right now, Lord, this is only because of that the charge sheet was, that is for drawing charges, Lordship, only these things has been. Now the prosecution, Lordship, this is a separate aspect, Lord.
No, the aspect of criminal prosecution and seeking prosecution sanction is a different aspect. But the allegations are totally on the selection, which is the subject matter in this writ petition. The entire selection is this question mark, where a criminal offense has been alleged and prima facie established in this investigation. It's in the court, it's a different matter whether you are able to prove it or not.
Lordship, yes. Number two, as verified in his affidavit, Lordship.
Who is to?
And, some doesn't exist, Lordship, what else?
Okay, what was his stand? What has happened to the criminal case?
Lordship, 3 searches have been filed and additional search has been filed against.
No, investigation
Lordship,
still.
the trial has not commenced, Lord.
Why this prosecution sanction was sought for when?
Against Articles.
When was it sought for? Long time back,
Long time. Maybe Lordship, the trial has started.
2021.
Yes.
We cannot just shut our eyes to the anomalies. Anomalies are very, very serious. Not anomalies, offenses involved. You get the instructions on the status of the criminal case. We'll have it when? After 10 days. Mr. Mohanta?
My lord. My lord.
Lord, I have a.
That is, my lord, in a separate chapter, my lord. Your lordship kindly.
The entire reading of the report by which prosecution sanction has been sought for. There are serious anomalies.
No, that anomalies, my lord, that regarding criminal case, they will take your own course, my lord. Your lordship kindly see, they were already.
This is the outcome of of those offense. Selection and appointment.
No, my lord, your lordship kindly see that already marked.
Can we just ignore all this? Can it be ignored?
But all are working, my lord, all day.
There is no challenge. Let there be a challenge.
There is
We'll
the order
examine.
passed by this honorable court. That's why, my lord, it is, my lord, they have been appointed, my lord.
Where is the order?
That order is your lordship.
No, was there any challenge to their appointments? Selection, like this case? No.
Here, my lord, here
He's concerned with lot number 12.
yes, lot number
Lot
12,
number
he
12.
says, his case is that, your lordship kindly see his pair, my lord.
Yes,
His pair is that, my lord.
12. Yes.
In the nature of sorcery should not be issued, set aside and cause the impugn recommendation made by the corrigendum dated the name of the petitioner in respondent as a regular in the lot number 12.
12.
B. It in the nature of mandamus to issue a direction to appoint the petitioner on the strength of the selection as per marriage serial number 12.
Yes.
Select is published in the Bhai order that in the alternative review the entire selection and select and appoint the most eligible candidate as per regular Canberra lot number on the basis of the actual mark is secured by petitioner in terms of the qualifying.
I mean to say actual mark in respect of qualifying examination, that is higher secondary mark.
Qualifying examination.
Yes, qualifying examination. I said.
High
my
secondary
prayer,
mark.
yes.
Then he
Actual
says
mark
that the
in terms of the
selection mark
qualifying.
is not there. He says that my qualifying mark because his high secondary is getting, he has to get more mark.
Because of the anomalous law.
How are marks allotted?
There's a, my lord.
Is it on a subjective basis or objective?
My lord.
Marks are allotted on subjective basis or objective basis?
Marks are probably there on the basis of interview, my lord.
That means a subjective basis,
My lord,
not on the basis of the marks secured in
My lord.
HSLC or.
my lord.
Then the question of discretion would come. If it was objective basis, we could have done this thing exercise ourselves, just for prima facie
My lord.
satisfaction.
No,
What is
if
the-
he is, suppose someone is graduate, he will not get an extra mark, my lord. Minimum qualification, my lord.
Yes.
Those who are, my lord, SSLD pass.
That is the only reason, that the marks given in the interview are totally under subjective satisfaction
My
of
lord.
the. So there, the question of the
No.
issue of.
So far, my knowledge goes, that is, my lord, there is a circular, my lord,
Hmm.
regarding how it downloads the appointment in advertisement itself, my lord, that is reflected.
And page 101 Lord, in terms of the PM vigilance case, they have initially suspended 4 of the petitioners, four Gamburas Lord, at page 101.
But they were again in step, my lord. They were in
That is
step.
another thing. But in terms
No,
of the,
you say, since you say that they were terminated,
In
but they
fact-
are instated, my lord.
in persons of the CM's vigilance case, Lord, what is the
Suspended, my lord.
the below mentioned Gambura have been arrested by vigilance PS case number so and so, Amendment Act, and detained in judicial custody on 21/2/2022.
Page?
Page, Lord, 100 is the type copy, 101 is the original one.
Yes, sir.
Aminul Islam was arrested.
Yes, this 4 Gamburas.
Aminul is why have you typed out only Aminul's name?
Only just one name has been typed out. There are 4 number of
No,
Gamburas.
why have you selected 2? I tell.
Gamburas are already instated.
You get the status of the, what is this? Charge sheeted before the special judge on 2023. Would have heard. Sri S.K. Das, learned counsel for the petitioner. Would have also heard. Miss M. Bhattacharya, learned additional senior advocate, son. You are appearing. Sri J, semicolon Sri J. and Dick, learned standing counsel, Revenue Department. Full stop. Sri T.J. Mahanta, learned senior counsel, is present for the response number 7. Full stop. Do instructions in the form of written communication dated 7/3/2024 has been obtained by the Learned State Council, comma, the aforesaid instructions pertain to a period pertain to the issue of filing of the charge sheet and the supplementary charge sheet in the connected vigilance case number 5 of 2021, which are events of 1/2/2022. Full stop. The submission of documents before the Court of the Special Judge is also of 3/8/2022 and 9/10/2023. Full stop. Para. Let instructions be obtained on the status of the trial. Full stop. Let this case be listed after 2 weeks to enable obtaining of such instructions. Full stop. Para, interim order passed earlier to continue till the next date of listing. List on, yes, tell us a date. Today is on 29th, 29/5. Madam, you take back this original. Yes, sorry about it. Mr. Goswami, your matter. 12:30. Yes.
Also, the petitioner initially appointed as a senior scientific assistant in serology division.
You are in item number?
Item number 7. Lord.
7. 4584.
4584. 18.
Petitioner appointed as
Senior scientific assistant.
senior scientific
Assistant in serology division. Forensic science laboratory, Guwahati.
in FSL,
In FSL. Lord.
Guwahati.
Okay.
Guwahati.
One.
Okay, then thereafter what happened?
Lordship, what happened? The next hierarchy is Lordship, junior scientific officer.
No, you are already senior scientific
now-
assistant.
Now,
Or next is officer.
next is junior scientific officer.
Next post, junior scientific officer. Okay.
Yes, sir. The required qualification for appointment to the next category is Lordship, 3 years experience.
Required eligibility. 3 years as senior scientific
Senior
assistant.
scientific assistant.
3 years. In
3 years.
cadre.
Next, for promotion, Lordship.
Yes.
But Lordship, petitioner was promoted to the post of junior scientific officer on 12/4/2006.
12.
12/4/2006.
Promoted. Petitioner promoted.
Next hierarchy. After delay of 7 years.
When were you appointed as senior scientific assistant?
In the year 1996. 1996.
After 7 years. Hmm.
I am eligible for promotion to the junior scientific officer on 19/3/1999.
Okay.
So the next hierarchy is Lordship, after junior scientific officer is scientific officer. That is also same Lordship, 3 years experience is required.
Scientific officer. Same eligibility.
Same category.
Same 3 years.
3 years Lordship.
Then
Then the petitioner promoted as scientific officer on 4/7/2014. He is eligible for appointment Lordship for promotion on 19/3/2009. There is a delay of 5 years.
yes.
After the Lordship, during the pendency of the case Lordship, the petitioner appointed as senior scientific officer in the year in the month of May 2021. The criteria for promotion for scientific officer to senior scientific officer is 5 years. Lordship. Earlier, both are 3 years, now this is 5 years.
Senior scientific officer.
Yes, Lordship. It is 5 years. The required qualification.
You completed in 19, 2 years delay.
I completed in 14, Lordship.
No, you completed
Yes, Lordship.
19, 2 years delay.
And Lordship, senior scientific officer to deputy director, also same, Lordship, 5 years is required. No, Lordship, I am eligible for scientific, senior scientific officer on 14, Lordship.
Why?
Because scientific officer I have been appointed from junior, appointed in the year 2006, Lordship.
No,
Delayed.
as scientific officer in 2014, you had said.
Yes, Lordship.
No, 4714, you had said.
Yes, 4714.
Then you said 5 years.
That is 5 years.
So it will become in 19. 19, you should have been promoted. You have been promoted in 21.
21.
So 2 years
Yes,
delay.
yes, 2 years delay.
2 years delay.
Yes, sir. And senior scientific appointed 5 years, Lordship. But I have not promoted, Lordship.
Now, what is the next post?
Next post is, Lordship. Now I am senior scientific officer. Next post is deputy director.
Deputy director.
Lordship.
Same 5 years.
Same 5 years. And deputy director to joint director also 5 years. Now,
Now you are a senior scientific officer.
now I am senior scientific officer.
Now you claim that you have become eligible in
14 for
no. Eligible for promotion to the post of deputy director. You would be eligible in 2016, 26. 5 years.
so if I am timely promoted, then I will be become eligible for in the 2014.
No, that is a different matter. You have to serve in the feeder cadre for 5 years.
5 years.
You have become a senior scientific officer only in May 2021.
May 20 as a senior scientific officer.
Senior scientific officer. Now, to become a deputy director, you need 5 years.
It is 5 years. It required as per rule laws.
Yes.
But there is a provision for relaxation of the rule laws.
Yes.
That is to say, pays.
Now, the initial delay, can it obliterate or do away with the requirement of serving 5 years in the feeder cadre? That is a different aspect. That in your initial promotions, there has been delay. But ultimately, the present issue is that you are aspiring to become a deputy director and a director.
Yes,
okay, but your post which you are now holding as senior scientific officer, you were promoted only in May 2021.
May 2021.
So if you add 5 years in 2026, you will be eligible.
Yes, sir. But there is a provision for relaxation.
Relaxation, what is the relaxation rules?
If you pays the state. Is 50 laws. Rule 28 laws.
Rule 28.
28. Where the government is satisfied that the operation of any of these rules possess undue hardship in any particular case, it may be dispensed with or relax the requirement of that rule to such extent and subject to such condition as it may consider necessary for dealing with the case in a just and equitable manner, provided that the case of any person shall not be dealt with any manner less favorable to him that provided in this rules. So earlier lawsuit and other candidates lawsuit promoted by invoking this rule lawsuit.
Relaxing rules.
And lawsuit
Who have been promoted?
I have in my affidavit in reply, I have stated that who have been promoted last week.
How many petitions are there? Three petitions. All in the rank of senior scientific
Now
officer.
we are all senior scientific officers.
You want to become a deputy director?
Sanction post is 9 last week.
How many vacancies are there?
Now 4 posts is 5 posts is vacant last week. I have annexed my affidavit in reply additional affidavit last. File on 18 to
Deputy
2022.
director is 9.
9 last week.
Vacancies,
Vacancy is 5.
present vacancies. 5. And who are the other contenders?
Other contenders was in the petition as well.
No, you are 3. Three of you are there.
We are 3 last.
Those 5 vacancies are still there.
It's still there last.
You want to say that the rules can be relaxed by taking into recourse Rule 28 and by relaxing the requirement of 5 years, you should be given deputy director
Right.
because in earlier occasions also there has been delay. That is your
That
case.
is my case.
And Mr. Sharma, you are for the other 2 cases.
M8. 04 of 2017. Facts are a little bit different, Lordship. Here in Lordship, he is holding the post of deputy director. He is serving as in charge of that post in toxicology division. Second.
Monalisa Kumar, Chaudhary,
Bimal Kaur.
Vimal Kumar.
Lordship, if his promotions were effected correctly on the date he was entitled, he would have been entitled for that post on 15/11/2013 itself. But then he was given the charge of that post with effect from 3/3/2016. His services has not been regularized in that post till date.
You are holding the post of deputy director on in-charge basis.
In toxicology division, Lordship.
On in-charge basis.
In such way.
From
3/3/2016.
3/3. 3/3.
2016.
From 16 you are holding on in-charge basis.
No.
Till now.
Not as subject.
Then, Mr. Sharma,
My instruction is that he is still working there.
from 16 to 2024, you are an in-charge deputy director.
Lot.
You also aspire to become a regular deputy director
Yes, sir.
because you have already
Sir, for longer than it's the qualifying period of service is 5 years. I have served for more than that.
yes, Mr.
And Lordship, the director has filed affidavit, Lordship, and they have admitted the fact that there was delay. But incidentally, the respondent number 1 in Mona Lisa Court, the other case, Lordship, they did not say anything about this.
No, but we can tell you one thing, Mr. Goswami, before even react. See, there has been delay earlier, but that delay will not, we cannot overlook the aspect of requirement of 5 years in the feeder cadre. Having said that, we are on the aspect of whether you can relax the rules by invoking Rule 28.
No, that is absolutely incorrect. No relaxation was so far made by the authorities for giving promotion any of the officers. That is incorrect.
No rule, but there is a provision.
Yes, provision is that was not invoked at any point of time.
Rule 28 never
Yes,
invoked.
my lord, in the first case, my lord, the promotion that has been granted now in the year 2021, that was not part of the pleading, my lord. At the time of filing the case, my lord.
We have already made it very clear. We are not going to the other earlier aspects. There has been delay. But
Yes, my
you
lord.
cannot
They-
raise
but,
it now.
that is also reasons. There are reasons, my lord. We have explained, my lord. In the first case, may I read all these statements? The first-
No, we may not go into all those.
And apart from all, my lord, there is no discrimination at all, number
No,
one.
no, no, see, no, no,
And my
that
lord,
you did
after-
not, that you did not
After
argue.
12 years, my lord, they
Yes.
raised this objection before this honorable report.
No, no, those we are not even taking into consideration.
Right.
Delay has happened, they did not come at that point of time, and promotion cannot be claimed as a matter of
Because
right.
of the eligibility.
Only because you have become eligible, you have to be promoted, nothing like that.
Yes.
But having said that, if one of the incumbents is working in an in-charge capacity
My
for
lord,
the
at
last
that
more
time
than-
in charge of the department, not as deputy director. He was 23rd. That is also not placed before this honorable report. We have instruction, my lord, during 2023, my lord. He has been promoted.
Now, what steps are you taking to fill up the post of deputy director?
No, deputy director, he has been promoted now, 2023.
Who?
The second, the Bimal Kaur.
Promoted?
Yes, not promoted.
For that, I left.
My lord, he is lucky enough, my lord, because of the ordinance, my lord. STP benefit he was given, my lord. Once your lordship will kindly remember, my lord, central government, my lord, Ahom community was also treated as STP, but the ordinance was lapsed. There was no act as such later on. He is lucky enough, my lord. For that benefit, my lord, out of 4 persons, my lord, he was given preference because of the STP, my lord. And now he is the deputy director, my lord. 2023, he has been promoted, my lord. That is also not part of the pleading. That I think, my lord, that has not been brought to the knowledge of this honorable report, my lord.
No, you still have 4 vacancies.
My lord.
You still have 4 vacancies of deputy director.
Deputy director, he has already been promoted,
No, no, you still have 4 vacancies.
my lord.
Bimal Kaur is out of the
Yes.
Three.
In case of my
others.
lord, first one, my lord. Lordship, that is a specific aberrance in our affidavit, my lord. Apart from all have been duly explained, my lord. Apart from all, my lord, the paragraph 12 of the affidavit.
Yes. What have you stated?
Among the vacant posts of deputy director, few posts of deputy director are not advertised where possibility of filling up by departmental promotion. The fact, the basic qualification required for the post of deputy director toxicology, which the petitioner claims. And toxicology and physics are MSc in chemistry and physics respectively. On the other hand, the petitioner is an MSc in applied botany
Maybe lordship, but then that.
and biotechnology. So against the post of my lord toxicology, my lord, deputy director toxicology, this appointment cannot be made. Otherwise, my lord, they have been, even during the pendency of the, my lord, petition, my lord, they have been promoted, my lord. In respect of petitioner number 1, my lord, 2021, he has been promoted, she has been promoted as senior scientific officer. What we can- And the third petitioner is also Dr. Monalisa Surri. He was also promoted in the year 2021 as senior scientific officer.
Not to that.
Okay, can it be done that if they otherwise fulfill the requisite educational background
For the purpose of promotion to the next
to
director.
next higher post of deputy
That
director,
will be certainly-
and they file an application
appropriate
for
application. they will
28,
file. Yes,
revoking
yes,
28,
certainly, madam.
invoking 28, and you can consider, you can
My-
reject also. It's not a mandate, mandamus from
But
the court.
election so far, my lord,
Not the qualification, only
yes.
the eligibility of feeder post.
yes, they have, my lord, right for making application and consideration. That is their right, my lord. Certainly they can do so.
That was
But
done.
it is
lordship.
not
File
correct.
application.
It is not correct to say that someone has been, by relaxing the provision, my lord, someone has been promoted. That is not correct. Absolutely incorrect. No
And-
one has so far
And,
been promoted.
regarding the vacancies of deputy
My
director,
lord.
which they are now
So
contending,
far, second petitioner is concerned, he has already been promoted to the post of deputy director.
now, for the remaining petitioners,
Two petitioners,
with
my
the
lord.
one Bimal already appointed,
The
remaining,
first one, my lord, that I have, my lord, already pointed out, my lord. for toxicology
No,
against.
no,
the toxicology.
just give us, that is for remaining two petitions to be considered. Be considered. There are how many vacancies of deputy director presently? I think 4. If Bimal has been appointed 4, because Gogoi said 5 vacancies were there. If-
But department, the deputy director, department.
That is the reason, that is what details you want to. 4, let us assume 4 vacancies of deputy director. What are the
I
departments?
think in the first deputy.
Petition number 1 in item number 7, Lordship. My petition is from the Serology division, Lordship.
Serology.
Serology. And the post of deputy director is 9 vacant in the Serology division under the forensic FSL.
So how many subdivisions are there in the post of?
After direction of this interference of this honorable earlier, my lord, division wise seniority was counted. I think nowadays, my lord, as a whole,
No, but the deputy director is under what discipline? What are the disciplines?
Discipline is different.
What are the discipline? Tell us, please. One is deputy director serology.
My lord,
Slide
paragraph
second
9,
from
paragraph 9,
7,
my lord, paragraph 9, my lord.
Please tell us, one is.
Paragraph 9, my lord, of this activity. Kindly have a look at.
Serology, then one is toxology.
Yes, my lord, before that, my lord, kindly have a look at.
Which
Paragraph 9 of the first activity.
Which petition?
WPC, my lord, 4584, 2018, first activity.
Yes.
They admitted that 4 posts of deputy director is
Just a
nine.
minute.
At the time of filing this case, my lord, that is the position, my lord. Because affidavit was filed, I think, before the last promotion. Paragraph 9, my. That will be clear.
By as per number?
That is Kumud Sharma, my lord. Director of Forensic Service.
Respondent number 5. 5, is it 5?
5.
Kumud Chandra Sharma, yes.
Yes. My lord, paragraph 9, my lord, kindly have it. With regard to averments.
Just a minute, please.
Paragraph 9.
21/8/2018. Para 9.
Yes, my lord. May I read it? Paragraph 11 to the, it's a, my lord, respond to the 11.
Yes,
paragraph.
yes.
With wisdom, the deponent backs to state that out of total sanctioned 12 posts of deputy directors,
Yes.
1 post is upgraded to joint director.
Hmm.
4 posts are filled up by departmental promotion.
Okay.
Out of remaining 7 posts, 4 candidates were selected for 4 vacant posts of deputy director by Assam Public Service Commission.
Yes.
As per recommendation of the APC, 3 deputy directors were appointed, but unfortunately 1 deputy director, namely Dr. Moitreyi Sharma, has already left this role. The 4th selected candidate yet to be get appointment due to court sent because of the interference of this, as regards this appointment, my lord. This is kept vacant. This way, only 3 posts of deputy director remain vacant and undisturbed at present. However, there exist 2 serving senior scientific officers who may be brought to under the zone of consideration for promotion to the vacant post of deputy director. Perhaps, my lord, during the pendency of the case, the petitioner, second petitioner, he has been promoted. Will remain 1. And
No. Please read the last 2 sentences.
My lord.
This way.
3 posts of deputy director
posts are
remain
there,
vacant
and there exist
undisturbed
two
at present.
persons.
However, there exist 2 serving senior scientific officers.
Yes.
Above.
When was the Bimal Kumar appointed?
As deputy director 2023.
23.
My lord.
So 1 post
Was
will go.
initially appointed on
Who may be brought under this zone.
1 post will go, 2 posts will
Certainly,
remain, 2
my
will
lord.
remain, 2 will remain.
However, there are 2 serving senior scientific officers. Yes. 2 senior scientific officers.
Are you indicating?
No, I have not compared all these things.
No, are you
Monalisa Chaudhary and she is senior to Bimal Kaur.
No. We're not on that. The last line, last 2 lines says that there are 3 posts
Yes,
of
that-
deputy director
Yes, yes,
which were vacant.
yes.
And there are two existing serving senior scientific officers who may be brought under consideration. These two
Out of two-
these two indicated which of the persons? Are the indication?
Certainly, my lord, the petitioner number 2.
No, there are three persons.
There are 3 persons. There are 3 posts of deputy directors and so. There exist 2 serving senior scientific officers.
But there are three
My lord, that.
petitioners.
As regards, my lord.
And your affidavit is of 2018.
My lord.
You say Bimal Kaur was appointed in the year 2023.
Yes.
So at the time of filing of this,
Right.
since we have 3 petitioners before us,
My
all serving in the post of senior scientific officer.
My lord.
Now, whether they are within the zone of consideration seniority wise,
My lord.
or are there persons above them?
Certainly seniority wise.
No, are there persons above you
No.
in the
No, no,
in the
no.
rank of?
That allegation is not there.
No, senior persons are not there.
Not there.
Not-
Lordship,
You are the
Lordship,
only
Lordship,
person.
Mona Lisa Chaudhary and I have been appointed the same day, Lordship, on 19.
No, Mr. Gogoi, you have not understood.
Lordship,
You are before this court. That's a different matter.
Lordship.
Are there any other persons in the rank of senior scientific officer who are not before this court and are still aspiring to become
Yes.
a deputy director?
there, sir.
So only because you have come to the court, we cannot direct that you should be, you have to be considered along with others. We do not know how many of you are there in the rank of senior scientific officer. Apart from the remaining 2,
Remaining.
Bimal is out, 2 are there.
That my seniority will be in the best position to ascertain.
Lordship.
No, I will certainly.
Now,
bring
can
all
you
these
just indicate to us how many senior scientific officers are there?
Yes.
Including the petitioners, remaining 2 petitioners. One is gone, Bimal is gone. In the cadre of seniors, Bimal is not a senior scientific officer. You are become a deputy director, so you are not within this fray. In the fray, how many of you are there? And if there are more than 2,
Yes.
then what
And against those vacant.
what
posts,
are their position in the seniority level?
Right.
You can come back at
Over.
2 o'clock,
That position might not. I'll try, but.
or if you try, otherwise you can have it tomorrow or day after tomorrow.
After tomorrow will be better, right?
Day after tomorrow.
Because I'll have to talk over phone, my lord.
Okay, okay. The first sorted out already.
To remain as part
Not parted, we'll have it.
for further hearing.
Yes,
There.
on the prayer of Sri, and I had the learned counsel for the parties, full stop para. On the prayer of Sri B. Goswami, learned additional AG Assam, the matter is deferred to Friday, date Diba, to enable him to obtain instructions with regard to how many personnel are working in the rank of senior scientific officer presently,
And
who
eligible-
can be considered for promotion to the next higher post of deputy director in the FSL. In the FSL. Full stop. Let this matter, no, deferred boli to kono na, list accordingly.
So Friday, my lord?
Friday.
All right.
If we come to a tentative finding or from your instructions that they are the only scientific, then we can ask them, close this, they can approach you with a petition for 28 and you apply your discretion, pass final orders.